Welcome to You and the Law. I'm Steve Cilenti.
And I'm Bob Lally.
With us today is Stephen Airola. He's an attorney with Airola and Airola. And I went to school with your brother, but don't hold that against me.
No, we won't.
Okay, good. Steve, we've had a number of questions from viewers dealing with easements, and I know that in the rural counties that easements can be a very big issue. What kind of different easements are there?
Well, we have several types of easements that exist in the law. The most specific kind of easements that we run across today are easements that are express easements. Those are the type of easements that are written in deeds or granted specifically in a legal document, granting to another person the right in that person's property. Besides express easements, there's also easements by implication, whereby a person who transfers a piece of property and forgets actually to transfer an easement in that property, it's impliedly reserved in that transfer of that piece of property.
And then there's also another type of easement that nobody intended, either they didn't intend it and they didn't imply it, it just kind of appears.
And that's the kind of easement that we see most litigation occurring in that area. And that kind of easement is called a prescriptive easement or an easement gained by adverse possession.
Okay, and let's first go back to the express one. That's one that we can actually go to the county recorder and take a look at, and it's in writing saying this is exactly where the easement is and what it's for, correct?
That's correct. It has specific terms as to the nature and extent of the easement, the use of the easement, and the period of time that the easement exists for. So it has particulars and very specific in nature, usually.
Excuse me, Steve, say somebody's buying into a place where there's a homeowner's situation. Should they be aware to look and see what type of easements are involved in that situation?
Well, when you have a homeowners association, specifically you do have homeowners association bylaws and covenants and conditions, which we call CC&Rs, that are very specific in nature, and they have all kinds of easements that are granted with those CC&Rs, and they have prohibitions that are built into those CC&Rs too that allow or do not allow specific activities within that homeowners associations. So that's a type of easement also.
I heard you mention that as an express easement, so could somebody find those if they went down recorded somewhere?
Yes, if you're talking about a subdivision, generally the covenants, conditions, and restrictions are always recorded. And when a person buys their real property in that subdivision, they are always given a copy of those CC&Rs by the title company. Or if they're not given the CC&Rs by the title company, they are referenced about where they can find them in the county recorder's document at the county recorder's office. But the insurance, or I should say the escrow company, does like to make sure that the buyer receives a separate copy of those conditions and restrictions.
I know that having bought property over the years, that when it goes through escrow or at some point prior to going through escrow, there's a list of what different easements that there may be, whether it's an access easement or utility easement, of some kind, but they're always in writing, and you may not be able to find it very easily, but as far as on the physical land, but it is there and it's quite expressed because you can read the detail. Correct?
Yes, that's true. The title companies, when they do their title report, they research the title and research and find any express written easements that have been granted prior to the prior owners, and those will be disclosed. However, you do get into the tricky area whereby easements that exist on the ground that may have been created by prescription are not disclosed by a review of the public records, and therefore the title company does not disclose those in your title report, and therefore you will have no knowledge of that easement. So it's important, if you're buying a piece of property, that you go out and physically inspect that property, and if there's any trails or evidence of a roadway on that property, that you ask your sales agent or broker, what is happening with this? Who is using this road? What's this for? I don't see it in the preliminary title report. Because those undisclosed easements, the easements that have no recorded history, are not protected or insured by the title companies.
As a matter of, though, the court or enforcement, this is kind of interesting because I'm just thinking in my mind, you're talking about express and you're talking about conflicting prescriptive easements that are in conflict with each other. Which takes precedent?
Well, actually, a prescriptive easement is not a prescriptive in writing, but it is a valid and existing easement. And so a prescriptive easement has just as much force as an express easement, and one does not prevail over the other. However, one has to go back and look at the use of the easement, how it's been made over the last several years, how it's used, the extent, etc. of that easement. So I can't say that one really prevails over the other. Each easement really depends upon the facts of each case.
Okay.
Now, before we get into prescriptive, in the express easement, where it's actually in writing, let's say I had an access road that went through my property to get to another property that many years later got their own access to the highway, so they're no longer using the easement through my property. Is there a way that I can acquire that back, the easement that goes through my property, because it's not being used anymore?
Well, an express easement can certainly be transferred back to the original owner of the property. And there's several ways that can happen. A person who desires to acquire that back can approach the owner of the easement and ask to repurchase that easement from the true owner. And certainly that can work. There is another aspect that one can do. One can actually block that easement and prevent the owner of the easement from using that easement any longer to gain access. And that would be termination of that easement, written easement by adverse possession. So there's several ways to terminate those easements.
Now, to me, it would seem that that could cause some real problems, that there's an easement through my property that, granted, they're not using, and so I erect a fence across it, now denying full access. I really don't own that. So they could actually come after me and sue me because I've now blocked that easement, even though they're not using it.
I was just wondering about that. Somebody has been going home for, say, 10 years, and they've been driving down the driveway going into their house, and all of a sudden there's a locked gate there, and they can't get into their house. What's their recourse?
Well, they've been using that road for the statutory period of time for 5 years, and if it's an express easement, or even if it's a prescriptive easement, their remedy would be to file an action with the Superior Court to quiet title to that easement, declaring that that easement is a valid and existing easement, and maybe suing that individual for trespass, for blocking their easement, and for damages that may likely follow. So the Superior Court does have the power to enforce easements and to remedy the situation.
Not small claims court, but the Superior Court. Am I?
Generally, small claims court does not determine or quantify the use of the easement. So we're talking about Superior Court and not small claims court. However, small claims court can be a basis for determining what repairs to an existing easement may be necessary.
So if somebody cut the fence that I erected, my damage would be the fence, but they could countersue me certainly. If I filed in small claims court because they cut my fence, they could actually bring it up to Superior Court and say, he blocked my easement, correct?
That's right, and that blocking of the easement could be a criminal matter also. Yes.
It would seem to me if there's a dispute over, again, we're talking about an express easement, the better way to do is, rather than use self-help, consult an attorney, find out what your remedies are and your different alternatives to either enforce or to terminate that easement, rather than trying to do it yourself and ending up with a real problem.
Like create a plan of action, a legal plan of action.
A legal plan of action, I think, is the appropriate term, yes.
Usually that is the more appropriate route to take. I often, however, do encourage people to go out and sometimes cut those locks, make their presence known that this is my easement, that I'm going to enforce my rights under my easement, and cutting locks, removing gates, removing fences, whatever is necessary. Sometimes we're still acting under the wild, wild west, Steve.
Hopefully not too far.
No.
All right. We've been focusing on express. Those are written. They're easy to find, whether they're driveway or access or utility. Then we get the implication. I sold this piece of property. It's implied that you're going to have to go through my property to get to the land I sold you. Otherwise, it's using a legal term, it's landlocked. But if somebody forgot to sell or an easement or grant an easement, can a person do something to get that easement by implication, move it to an express?
Well, sometimes the term implied easement or easement by necessity is used kind of interchangeably. First of all, an easement by necessity is an easement that is created where a common owner owned both parcels of land prior to the sale and then sold one of the properties without granting an express easement. In that case, there is an easement by necessity. But in California, we have many parcels that are landlocked, many parcels that are specifically sold without an easement. And therefore, landlocked parcels in California are very common. So necessity doesn't always apply or imply that there is no access or that one has to grant an access to that property. That is not the case.
All right. So if I bought a piece of land and I didn't buy it from a contiguous owner, but from somebody else, can I force one of the adjacent property owners to give me access?
Without more facts, you cannot force that adjacent property owner to give you access, and thus you would be landlocked.
What are the facts that you would need?
You would need to find out how the prior owner accessed that property. Did they follow a specific trail or roadway? Did they use it for more than 5 years? Did they use it with the permission of the prior or of the owner that we call the servient tenement? Did they use it with permission? And these are the facts that we'd have to go back and explore to see if, in fact, a parcel that does not have access can gain access by other means or by adverse possession.
In my hypothetical, great-granddad, the person I bought it from, his great-granddad used it, and he has no idea how great-granddad got to the property. There's just no history there to show that there was any access ever for many, many, many years. Am I going to end up with a piece of land possibly that I have no access to?
You certainly could. If you can't create the history and go back and really research the facts to see how that property was accessed, you could very well end up with a landlocked piece of property.
So in that case, if I'm looking at a piece of property that is landlocked, I can see that there's no history there, would it not, before I buy the land, be a good idea to get an easement or access firmed up before I actually buy the property, correct?
You would certainly be a prudent person to do that, because otherwise you're going to be buying a piece of property that you are not guaranteed access to. And I don't think that if you're going to want to build a house, certainly any bank is going to want to make sure that you have adequate access to that property, and adequate access would be a written easement.
Okay, here, I think there's a little bit of lawyer coming out of me in this question. But let's say you have a landlocked piece of land and there's no known history. But have you ever seen a situation where you've investigated and there's been a new unknown history, and how long does a history have to be?
Well, in my own practice, we have always been able to go back and research prior owners of the property, all around the property, people who have timbered that property, people who have utilized that property for hunting and fishing, and they sometimes it's extensive research that needs to be done, but facts usually can always be unearthed in one way or another. And so in my practice, I have not come into the situation where you can't uncover any facts whatsoever. Neighbors, contractors, prior owners, real estate agents, longtime old family members usually can shed some light on that property and how it's been utilized. So very rarely is the case that you're not going to find any facts.
Yeah, what about, because we do have Bureau of Land Management land up here, if the traditional access has been through BLM land, does the government generally give you an express grant for an easement, or how do they handle it?
Well, the Bureau of Land Management or Forest Service does not generally give easements over and across their property. In fact, you cannot acquire an easement by adverse possession against a government entity. So if you've been accessing government or your property over government land, then you have a problem.
In other words, they can close that road and it will stay closed.
You can close that. They will close that road, and they can lock you out of your property. Absolutely.
So you may not be landlocked when you bought it, but do your homework first.
Do your homework first, and make sure that you have adequate access, written access, and are able to access your property. Absolutely.
What if you had a piece, I'm sorry, is it okay?
Go right ahead.
Thank you. If you had a piece of property and you had power lines going across it, can you do anything about that, or does a public entity sometimes have easements?
Well, there are many types of easements, of course. There's an easement for ingress and egress, and that's for a roadway. There's an ingress and egress, there's a easement for power lines and power poles that are granted by a private individual for PG&E. And that is a specific grant of easement for power lines and power poles, for utilities only. And that does not carry with it the right of walking or driving an automobile, but only for the conveyance of specific utilities.
So people can get compensation for having power lines put across their land?
Well, yes, you can certainly get compensation. However, most people are readily willing to grant PG&E power access over and across their property, because there is a benefit to them in the long run that they will be serviced with power and telephone and sometimes cable TV and these various types of utilities that become available.
But that's a whole different animal when you start
Right.
talking about utilities. You mentioned prescription or adverse possession. Now, this is not an express, they're not implied, it's just that somebody starts walking across your property, don't ask for consent. Maybe they're going to their favorite fishing hole, and they decided through your land as a shortcut. What are prescription or adverse possession easements?
Well, the law does give beneficial interest to an individual who has used an easement or a right-of-way for more than 5 years as their own under color of title and which has been hostile to the true owner. And so this is a way that the law has evolved over the years to grant an individual a right to get to their property. And it is a very highly litigated area of law that we run into in California, and particularly in Calaveras County, Amador County, Tuolumne County, and the Mother Lode Gold Rush area. So it is a big area of law, and each case falls on their facts.
So if I'm going through somebody's property to go to my favorite fishing hole, and my dad did it before me, and I'm now doing it, it's gone on for many years, and suddenly the person says, you can't come here anymore. Got to go elsewhere. I could actually bring an action against that landowner?
That's correct. You would have to file an action with the Superior Court, an action to quiet title to that easement, claiming that easement is your easement, that you have the right to use that, and that easement is good for all time. The court would then make a determination if that is a true and existing easement, looking to see if all of the elements of prescriptive easement have been established. If they have been established, then the court will issue a judgment quieting title to that easement. And that judgment would then be recorded with the appropriate recorder's office in that particular county. And that recorded judgment would then become your new easement.
All right. Changing the facts slightly, I decided that because my father did, now I want to go hunt on somebody's property. Not a particular destination, just the land itself for the sole purpose of hunting. Just because I had rights before, or I did it before, that doesn't necessarily grant me adverse possession type of easement or right to that go on that property, does it?
No, if you had prior rights that have not been exercised for a period of time, mere use alone does not terminate the right to an easement. However, use coupled with other facts may give rise to a termination of that. For instance, if the landowner erected no hunting signs and trespassing prohibited, and if those signs existed for, say, 5 years or longer, then it will prevent a specific individual from acquiring or reacquiring any types of rights in the land of another.
For our viewers, do be careful on crossing someone's land for sporting purposes, whether it's fishing or hunting, because there are certain fish and game laws that require that your access be in writing. Just because you say you've got a prescriptive right because you've been going there for years may not protect you. So it's always wise to speak to legal counsel before you start exercising what you think your rights are.
Now, I would like to add that under the Civil Code, I believe it's Civil Code Section 1008, there is a sign that landowners can post that says the right to cross this piece of property is revocable at any time, and therefore no individual will gain any type of easement over and across that property. And you'll see this a lot in parking lots, in driveways, and other areas where it's utilized by the public. And so these signs have a way then of preventing any individual from acquiring an easement by prescription.
Excuse me, Steve, you mentioned in one of your comments a while back that the person be using the property under color of title. What does that mean?
Well, under color of title means that that person is entering into the use based upon a good factual situation. So if he was granted an easement over and across a piece of property, perhaps the easement was never specifically delineated on a map or on a roadway, but he does have the right to utilize the easement. And so color of title also can refer to a defective description in a deed that did not adequately or defectively describe the easement. And so under color of title is another term that the law says, well, a person's going to have to show that they have some basis for the easement in order to establish a prescriptive easement. So there's many variations on how a color of title can arise.
Okay.
Now, there are some situations where if I granted somebody the right to cross my property, and I wrote out a note, I give Steve Airola permission to cross my property to go fishing, what happens when I pass away? Do you have a continued right since I gave you specifically permission?
Well, permission by a landowner does not ripen into an easement or a prescriptive easement. And permission I believe, will succeed and continue upon the death of that original grantee of the permission or license. But the heirs of that person can revoke that license at any time. So once that agreement or authorization has been given, it can certainly be revoked and would not ripen into an easement, since permission destroys any type of adverse possession.
You mentioned license, and as I recall, that is a right to access or do something usually for a specific period of time or a certain event, but it's never ripens, as you said, into an easement itself.
That's right.
Oh.
That's right.
Okay. When in dealing with Calaveras and Amador County, the local counties, what is the biggest problem that you see in dealing with easements?
I think that a lot of questions arise as to the nature and extent of the easement, as well as the repairs to the easement, and can one cut trees or can one cut brush off of the easement? And this is an area that gets to be very touchy and very tricky. And so a lot of disputes, neighborly disputes, and with landowners, where there's multiple owners of the easement, they get into a dispute as what can be cut, how far can the easement be trimmed back for, and how wide the easement is, and these, etc. These kind of problems kind of arise mostly.
If there's an easement that needs repair, can the person, who's responsible for that?
Well, if there is no specific terms or conditions with respect to the maintenance of an easement, the law does set up a specific Civil Code section 845, that says an owner of the easement has the obligation to keep that easement in good repair. And the Superior Court does have jurisdiction to determine how much a landowner should pay for a repair or contribution for that easement.
Obviously, easements are a very big topic, whether you're the owner or the user of the easement. If you have a question, do call somebody that does know something about easements. Thank you for joining us today on You and the Law.